making a confession or the alleged confession before Mrs. Cronje. And it's evidenced by this court from the state that he was transported by Sergeant Mkhane and Sergeant Mabena, and they were escorted by the SWAT members to Boksburg Magistrate Court. The state further led evidence that the alleged confession was made freely and voluntarily, in sound and sober senses, without being unduly influenced, before a magistrate, Mrs. Vivian Cronje, who also confirmed that she participated in the taking of the confession in the services of an interpreter. Ms. Mutlaping was also used, and the state submitted evidence through Mrs. Cronje that accused number 2 signed the statement, and that has been confirmed by Ms. Mutlaping, who gave evidence that she's the one who gave accused number 2 a pen to sign. The state further alleges, after the taking of the alleged confession by the learned magistrate Cronje, to taking accused number 2 back to Pretoria Mort, where he was booked in. Then the evidence of the state further is about the first appearances of all the accused in Boksburg Court on the 27th of October 2020. Before their appearances, the state led evidence that on the 26th of October 2020, they formally charged the accused. On the 27th of November, the state further led evidence on the second appearance of all the accused before the magistrate in Boksburg, and the 5th of March 2021. My Lord, in summary, the defense is going to respectfully submit that from the evidence given by accused number 1, that he was assaulted, that he was tortured, that he was choked, it's the evidence that the court at the end of the day will make a ruling in terms of whether there was such an inducement. Accused number 1 says, yes, after I was assaulted, I had no choice. I had to protect my life because there was no one who could assist me. He had no option but to sign a statement. Then the defense will later then address legal issues in terms of the admissibility of such processes or proceedings of recording a confession. It's evidence also by accused number 1 that pointing out of the 5th of June 2020, it did not point out any place. He disputes that he directed the driver to a place where the alleged offense, or a particular place in Vosloorus. And he further disputes the averment of the state of Colonel Radebe, who said, accused number 1 said, if you can take me to one of the entrances in Vosloorus, I'll be able to direct you or take you to that particular place. What is to be decided by this honorable court? Firstly, without wasting the court's time, we want to look at how accused number 1 was arrested on the strength of a J50. It is the submission by this defense that when an application was brought, there's no evidence before this court as to how was that application. As when that evidence is compared to the evidence of Brigadier Gininda, who told this honorable court that he brought an application in Boksburg Magistrate Court. In relation to evidence by Sergeant Mngmezulu, firstly, Sergeant Mngmezulu is not a commissioned officer. Section 43 deals with procedure to bring an application before a magistrate or justice for a warrant of arrest of a particular suspect. The persons entrusted or empowered, sorry my lord, to make such an application is the commissioned officer or the state prosecutor. The investigating officer, if he or she is not a commissioned officer, cannot bring an application before a magistrate. That proposition is, and the support of Section 43 is cited in Maposa versus the Minister of Police. My lord, I think the full citation is on my head. But there, in that case, we have, it's a civil suit against the Minister of Police, in that the plaintiff in that matter averred that he was unlawfully and wrongfully arrested on the strength of a J50. On the facts of that case, to support the principle is that Warrant Officer Comradi prepared an affidavit in support of the application, and the application was brought by a commissioned officer, Colonel Wenzel. So in my submission is that in the absence of this of evidence from the state side to suggest that a proper application was brought that warranted to deprive the liberty of accused number 1, is that that J50 upon which accused number 1 was arrested on its strength was illegitimate. Hence, the defense will move a submission that it was an irregular process to arrest accused number 1 on the 30th of May 2020. On the arrest of accused number 1 on the 19th of March 2019, he was arrested without a warrant of arrest. And the provisions of Section 40, 1, I think subsection B, are applicable, subject to confirmation, my lord. But the importance and the significance of that evidence is that, firstly, the state did not contest that accused number 1 was arrested on the 19th of March 2019. To move forward in what actually transpired, the defense will submit and argue that Colonel Mboto, in terms of Section 217, 1A of the Criminal Procedure Act, had no, this is what the defense will submit, that in terms of his rank, he is a commissioned officer. And this has been put to Brigadier Gininda when he testified as the head of the investigation, that there is a certificate which is issued for a person to be a justice of the peace. It's an A4 size certificate. And in terms of Section 217, 1A, confession made before a non-judicial officer, that provision relates to a confession to be taken before a magistrate. And the question of law is, who is the justice of the peace in terms of that provision? It is apparently clear that the powers conferred to the appointment of the justice of the peace are provided or prescribed under Section 334 of the Criminal Procedure Act, whereby it is stated that the National Commissioner is the one who appoints a justice of the peace on various districts. And it also, that provision, Section 334, 1, and other relevant provisions, deals with specific matters to be taken to a justice of the peace. There is no amendment of Section 217(1)(a) that is prescribed to include all the colonels as justices of the peace because of their ranks. That's my submission, that before this Honorable Court, it has not been proven by the state that Colonel Mboto produced that certificate and proved that he was the justice of the peace. Same applies to Colonel Rapatu. Colonel Rapatu, when I came on board, I canvassed this aspect with him during cross-examination. He took out an appointment certificate and said he was appointed by Ria Pierre, the National Commissioner. That's not what is required. That's the submission of the defense. Number two. Sorry, my lord. May I just have a seat? Number two, the defense would like the court to look at the date, the time accused number one was arrested. He was arrested, I think it was 12 minutes past, it's 12:30, according to the evidence of the state, but that is not in dispute. When he was arrested, on the same day, at night, the state alleges that he volunteered the information relating to the death of Senzo Mayo. And the state adamantly, and in terms of what Brigadier Kininda said, I was waiting for this time. There's something on my shoulders that I wanted to offload. This is the right time. The question is, if it was the right time in 2020, why it was not the right time in 2019 when he was arrested to offload that load? And the most important aspect that is important and which the defense will submit, that it was improper for the for Colonel Mboto to take a confession, even Colonel Rapatu, without the assistance of the interpreter. This is what Judge, I think it's Judge Brooke, in State versus Koki, this is what he maintained in paragraph 50, the relevance of an interpreter. That's why he mentioned that if the proformas and the statements attached thereto are made, the questionnaire is in English, and the answers given there are in English, then the competency of the Commission Officer Mboto in terms of English is at stake. It is also contended, it is also submitted, it is also held in that matter of State versus Koki about the involvement of a commission of a person who's taking a confession, and it is made in the same department by the police officer. That's why he mentioned in paragraph 53 that the legislature has seen it fit that magistrates should be used to take confessions. But this is the summary of what I've submitted in my written heads, my Lord. So, my submission is that both confessions allegedly made by accused number 1 and number 2 must not be considered as confessions that the commission officers complied with the provisions of section 217.
Even Mrs. Kronje.
Now I'm getting to Mrs. Kronje, madam.
I see.
My Lord, may I request Mr. Ramsipiti to read it for me?
What is the reason?
Is it paragraph?
Hello?
Paragraph 50, my Lord.
Yeah, fine.
Yes.
If it may please the court, my Lord, I'm reading from S versus Polki, the citation, I believe it's in Mr. Mngmezulu's arguments. At paragraph 50 thereof, the court remarked, all too frequently commissioned officers who record confessions do not use the services of an interpreter. That he or she and the suspect may both speak the same language, in this case is Xhosa, is not the only consideration. Questions on the pro forma are set out in English, so too are recorded answers as have been made by the suspect. The statement itself is recorded in English. What is never known is the competency in English of any particular commissioned officer. He or she is not a sworn interpreter. In court proceedings, they most often give evidence making use of the services of an interpreter. The reliability and accuracy of the statement is frequently called into question. It is frequently asserted that the statement was not recorded correctly and was not read back to the suspect, whether in English or in the language of its origin. Many of the routine concerns surrounding the accuracy of the record of proceedings pertaining to the obtaining of a confession and the level of compliance thereof required by the Constitution of those taking the statement could be overcome by having the additional input of a sworn interpreter during the process. Interpreters form an integral part of the magistrate's court proceedings. They are almost invariably used by magistrates when confession is recorded. The comments made in Ntantiso can be added to by the observation that the use of an interpreter would also be of great assistance in the attainment of the constitutional goal, a fair trial. Okay. And then we go to paragraph 53 thereof, my Lord. It says, and I quote, the time may well have arrived for the legislature to give serious consideration to the amendment of the CPA to remove the possibility that a confession may be recorded by a commissioned officer of the same force which is charged with the investigation duties. This would go a long way to ensure that the quality of the investigative work shows improvement, which is necessary to ensure an improvement in the rate of successful prosecutions for serious crimes in this country. I have little doubt that the members of the South African Police Services were aware that at some point during the investigation, there may well be magistral scrutiny of their background leading to the recordal of a confession. There would be a resistance on the part of the investigation team to resort to the improper use of police force or violence. That's what I quote, my lord.
Yes, thanks.
Thank you, my lord. That's the submission by the,
Yeah.
by the defense in relation to the admissibility of such confessions where an interpreter was not involved. There is that likelihood of misunderstanding. My lord, may I further address the court on on the evidence of the pointings out that the state has led evidence that Colonel Adv on the 5th of June 2020, accused number 1 pointed out freely and voluntarily. And in the same capacity as a commission officer, I submit that an interpreter was also not involved. The state must prove beyond reasonable doubt that a particular confession in terms of section 217 or a pointings out in terms of section 218 or an admission in terms of section 219 capital letter A must have been made freely and voluntarily in sound and sober senses without being influenced thereto. It's my submission that the state has dismally failed to prove those elements, those requirements. In the state's failure to prove those elements dismally, the state did not satisfy this court that the rights of both accused in terms of section 35 of the Constitution were properly explained. And beside being the rights being explained to the suspects or to the accused person, accused 1 and 2, the question is, if accused number 1 was arrested on the 30th, if the law requires that he must be taken to court within 48 hours, and a confession was, as the state contended, it was already taken from accused number 1 on the 30th. Why was he still kept, or why was he delayed from being taken to court? As I submit that when one looking at the definition of a confession, it's an unequivocal admission of guilt. So, in the premise of law, there is a prima facie case established by such a confession. Why was he not taken to court? Instead, the state used a strategy to investigate the case of Senzo Meiwa whilst keeping the accused in custody for other matters. If I'm not going to if I'm not quoting my colleague Advocate Baloyi, in his submissions, he also mentioned something similar to what is happening in Durban in that case of AKA. Is the same strategy that is used in this court, in this.
Which case is that now?
My Lord, is the one that...
Can this court take cognizance of that?
But I'm glad if the court mentions that, but it has never been canvassed to the state.
No, I'm dealing with the law. I'm not dealing with any other thing.
Yes, my Lord, but let's look at in...
No. That's gossip as far as I'm concerned. It's not law.
But
there's no judge who has found that this A, B, C, D. Please,
may I withdraw it?
Let's speak about law, not mlevo, gossip and whatever.
But that should have been conversed with the state as well, my Lord, yesterday.
No. You're arguing. He was making a comment about Durban.
That's what I wanted to do. May I retract that with due respect, my Lord?
Hello?
May I retract that? And
yeah,
proceed?
really.
Thank you, my Lord.
Mr. Mngmezulu, do you quote Mlevo as a quote? Gossip. AK is arrested, he was driving, where?
You can't achieve this.
Thank you.
Thank
Yes.
you. Thank you, my Lord. May I proceed?
Yes.
The rights of accused number 1 and number 2 were violated. As I've indicated in terms of the arrest was unlawful in respect of accused number 1. Number 2, there was no warrant of arrest when he was arrested for a murder case of Kwanongom. Up to now, the state has closed its case. Accused number 2 has never been taken to Kwanongom. It's my submission that he was unlawfully arrested and kept in custody. That violated his right to freedom. My Lord, another important aspect that I wish to submit before this honorable court relates to the dates in which these accused were charged, formally charged. Accused number 1 requested to see his fingerprints in order to prove that he was charged on the 26th of August. But the date of the statement given to accused number 1 reflected the 23rd of August 2020. So up to now, the state has not proven evidence rebutted or submitted by accused number 1 when he took a stand that he was not formally charged on the 26th of October. The same applies to accused number 2. He was not charged on the 26th of October 2020. It's my submission that the state, through the officers concerned, wanted to fall within the ambit of 48 hours period to take them to court. My Lord, these are confessions. And this court this court has to determine the admissibility thereof. May I submit that there is a provision in terms of section 219 that deals with extracurricular statements. And that provision is confirmed in State versus Fortune Ngwenya. I'll give the full citations if so required. State versus Ngwenya, Fortune Ngwenya, State versus Magwaza, and State versus Muchili or Musili.
Muchinindi.
Muchili. Yes, ma'am. Thank you. Relating to the admissibility of an extracurricular statement made by one person implicating other suspects. The courts have found that those kinds of statements cannot be admissible against the other on the reasons of hearsay evidence, on the reason of the right to remain silent in respect of other suspects.
Yeah, the right case there is State versus Mulimi,
Modi, thank you, my lord. That's the one that I was.
Constitutional Court.
State versus Modi. Thank you very much. It's my submission that, my lord,
Your colleague is laughing at me. Mr. Mngmezulu.
that anything said by accused number one will only be relevant insofar as what he made on that confession. Same applies to accused number two. Anything that is said about accused number one in his statement, that cannot affect accused number one. Even accused number two, anything that is said against 3, 4, and 5 cannot stand against those accused. May I move forward, my lord, by saying, looking at evidence of the lead investigator as the state has led evidence of Brigadier Kininda. Brigadier Kininda, with the years of experience, I'll submit that certain important things he did not do during the investigations of this case. What is required from Maposa versus the Minister of Police in relation to the discretion that a commissioned officer must apply when he brings an application under Section 43 of Act 51 of 1977. My submission is that Brigadier Kininda misrepresented the facts to secure the issuing of the warrants of arrest of these accused persons. I'll submit with due respect that the mere fact that when he was confronted during cross-examination, he did not state the whereabouts of the accused. In that application, in that form, it appears that the address of the applicants were unknown. And in his affidavit that was read before this court, there's no way he averred that accused number 1 or number 2 was in this particular prison when he brought the application. One may then look on the legal aspect, on the context of a definition attached to an arrested person. If you deprive somebody of his liberty, in terms of Section 40 of the Criminal Procedure Act, by arresting him with or without a warrant, that's an arrest, my lord. And I've conversed with Brigadier Kininda that the procedure that he was supposed to follow, whether it's provided by the national instruction or otherwise, but the logic, the procedure was to requisition these persons that were in respective prisons into the court when the matter is placed on the roll. But I find no reason to hide the whereabouts of the suspects. Their names are appearing on the application and that prescribed form. What was a reasonable suspicion for him to bring this application? The application is brought on the 23rd of October 2020. Accused number 1, the state alleged that he made a confession on the 30th of May. 4 months down the line, Brigadier Kininda brings an application before a magistrate, misleading, misrepresenting facts. Accused number 2, arrested on the 16th of June 2020. Application is brought 23 October 2020. That warrant of arrest that was issued on the 23rd of October 2020 was unlawfully and wrongfully issued on the misrepresentation given by the commissioned officer, Brigadier Kininda. In Maposa's case, Judge Mahalelo was concerned about the independent opinion of the commissioned officer or the person who's bringing the application. I will make this submission based on the second affidavit read before this honorable court A227 statement by Brigadier Gininda. In A189 statement, or 187, he mentioned 5 suspects when he brought the application. In A227, he mentioned 6 accused persons. That's why I wish to draw the court's attention on the independent opinion of the commission officer. In 227, A227 affidavit, he mentions the 6th suspect, Kelly Kumar. Her involvement in the carrying out of a contractual killing or a hit. Now, that's how I draw the court's attention on what is required by Maposa's case in the independent opinion. I do not intend to call or to bring the evidence of the state in the main trial. But one knows, and it's before this honorable court, that accused are facing a murder case, attempted murder, robbery with aggravating circumstances, possession of unlicensed firearm and ammunition. The evidence led already for a period of more than 7 months has been extinguished or has been destroyed by one affidavit which was read for 10 minutes, if not less than 10 minutes. That's how he exercises independence, to make such an affidavit. What is he doing? What is his intention? As the head of the investigating unit, cold case unit, does he want to lead evidence to the effect that the court seized with this matter to decide on the admissibility of a confession? Will this confession relate to robbery, or will this confession relate to a hit? Because it is said under oath that it was not a robbery went wrong. It was a hit. But the court has not listened to any evidence of the state witnesses prior to this interlocutory application of evidence of hit. Instead, the court has the evidence of a robbery went wrong. So now this is now taken away by Brigadier Gininda in his affidavit. But the most crucial, important, and of significance is whether, if this court was to determine the admissibility of these confessions, will they relate according to the independent opinion of Brigadier Gininda on these two opinions? There's evidence by Warrant Officer Mako, who told this court that no, there was a difference of opinions amongst the people that were, or amongst the officers that were appointed by the National Commissioner and the Minister to investigate it. According to Warrant Officer Makubo, there were 4. It's Colonel Butelezi, Colonel Ramkhala, my lord, and the then Colonel Geninda at that time, and Warrant Officer Makubo. Officer Makubo at that time, or
Mr. Mngmezulu, you want us to traverse the merits as you are doing?
no, my lord.
The law says I shouldn't allow you.
Thank you.
You want the case?
So, my lord,
I can quote it for you.
yes, ma'am. May I be clear, my lord, in terms of what the court is saying?
The merits. Warrant Officer Makubo came here and testified about the merits. He never testified about the trial within the trial. Never. Said, blah, 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 blah.
No,
But me, I know nothing about how the confessions were taken. That's his evidence. But
That's
then
good.
he talks about going to Turkop, being directed, turning right, turning left, eventually getting there, etc., etc. Those are the merits.
My lord, may I just leave it and
Hello?
say, may I leave it by saying there's evidence that there were different opinions. That's what I wanted to say.
In the merits.
Sorry, my lord.
In the merits.
Through the investigations. My lord,
Yes, I agree with you. In the
Yes,
merits.
yes.
Not in the trial within the trial.
That's correct, my lord.
Yes, I
Thank
have a
you.
problem with that.
Thank you, my lord. May I move on by saying, my lord, sorry? Okay, no. Thanks. Thank you, my lord. My lord, the aspect of may I just have a quick recollection, my lord, of my, because everything is in my may I just quickly my lord, may I have 5 minutes? I just want to make certain.
Are you through with your hits?
No, I'm not.
That's it.
I still have to canvass the issue of the OBs, the occurrence book, and the...
Yeah, you can do so now. Why don't you do it until the thoughts come back to you? Because now you are blank.
That's why I'm going to revisit. I'm taking everything in my mind, from my mind. May I request a few minutes?
What's the time, Mr. Baloy?
16 minutes to 1, my lord.
Okay, let's come back at 2.
Thank you.
Sorry. Where's Mr. Jonas? Jonas. Come here.